intellectual property organization. He is also a best performer as at USLLS LAC. He is also a former researcher at Department of Justice, Ministry of Law and Justice. So, and today the topic of the webinar is murder and attempt to murder. And Mr. Mohit will be covering journey of a criminal offense, murder and attempt to murder, transfer of malice, and many more topics. So, on to you, Mr. Mohit.
Yeah. Thanks a lot for the warm welcome, Hafta. And first of all, I would like to wish a very happy International Literacy Day to each and every one of you who are available right now. And I would like to thank the platform of Law Sikho, Ramanuj, and Abhyuday sir as well for providing me this opportunity. So without wasting any time, I think due to paucity of time, we need to start off. So exactly, if we go by the, first of all, guys, am I clear now?
Please, if you can listen to properly, please write in the chat box.
Yeah, fair enough.
Okay.
Yeah, thank you.
Sure. Yeah.
So if you go by the regime of the today's concern list, then probably I need to start with the journey of the crime. So exactly what happens? The first stage is usually the stage which is known as the mental stage, in which the malice is involved. The word malice can be understood by doing the implication that what is the guiltiness of mind there which is involved. Now, generally we are having all the offenses that start with malice itself. But yeah, there are some exceptions in which malice is not required, neither in terms of intention, neither in terms of knowledge, neither in terms of reason to believe or any other. Because in that particular offenses, there is strict liability involved. And in that strict liability scenario, you may kindly take note of various offenses. Just for example, you may refer to section 359, kidnapping, 360, 361. And apart from that, a very common example that we used to share is 304A. That is death by negligence. The second stage that usually comes is the stage of preparation, in which you usually gather all the things in order to give your preparations a very nice start, gathering of weapons, making of plans. So it is known as preparation stage. And if we go by the Indian policy pertaining to criminal offenses, to exactly what is done, we are having several offenses that are punishable at the stage of preparation stage only. Just for example, waging war, dacoity, counterfeiting of coins, and etc. Now, the most important topic of this concerned sub-subject matter for today's discussion is attempt. It will be highly beneficial when I will be discussing upon the subject matter of murder and attempt to murder. So exactly what happens whenever an attempt is taken place? So there always will be two things, the outcomes of that. And those outcomes are, if the attempt gets failed, then it's gonna remain in the stage of attempt only. But on the very other hand, if the attempt gets successful, then there will be a stage of completion. Now, your liability will be dependent upon the kind of offense which you have done under that particular section. Just for example, if you're liable under murder, then you will be liable under 302. On the very other hand, if you're liable for culpable homicide, then your liability will be decided by section 304 IPC. So this is the journey of a crime in each and every kind of probable offenses which takes place. The exceptions have been duly discussed with all of you. Now, apart from that, now coming to the main subject matter of today's theme, that is murder and attempt to murder. So I would like to start with murder. Now, it is pertinent to mention here that it is not at all possible to define the act of murder without focusing upon section 299 culpable homicide, because there is a different kind of analogies and theories that are much applicable to this particular scenario. Until and unless you prove section 299 culpable homicide, you cannot get directly to murder. Just for an example, if you go by the regime of two theories, first, there is a genus and species theory. So here, culpable homicide, which is mentioned under section 299, is the genus. And on the very other hand, when you talk about section 300 murder, it is the species of culpable homicide itself. So exactly what happens, I must say that as far the legal scenario is concerned, not from a layman perspective, so what murder is? Murder is nothing but it is an aggravated form of culpable homicide itself. So exactly what has been done in our Indian jurisprudential point of view regarding murder and culpable homicide. First, you need to prove all the essential ingredients which are mentioned under section 299 of culpable homicide. As soon as you prove them out, then directly you will be going to, or I should say, the prosecution will be going to section 300 because it is having now the additional or the specie elements in it, which are implicit. After that, what exactly happens? If the specie elements of murder also gets proved, in addition to the section 299 genus elements, then under section 105 Indian Evidence Act, the defense will raise the plea in order to get all the exceptions which will be taking place in order to get the liability of yours back to section 299. So I must say that each and every one of you, it will be highly beneficial in case if you can have a your criminal manual around you, because it will be beneficial in order to understand the subject matter of this entire legal theory. So if we go for the culpable homicide, so it's a kind of legal analogy how you see the things out. Basically, it generally read as whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. As simple as that. But the things are not that simple, which they are appearing. What exactly need to be done here, there should be a bifurcation should take place. This particular section 299 is carrying three subclauses in it. First, if you say at 299 clause 1, just for example, for your own judicial prudence, 299 clause 1 directly says that whoever causes death by doing an act with intention of causing death. Now, exactly what is happening here, intention, the word intention is directly going towards the word desire. And the word desire is corresponding to either two things. The first can be that there will be some kind of extra assurance that, yeah, death will be directly caused. There is no breakage between the act and the intention of a person. And secondly, there should be a kind of certainty that in all particular circumstances, death will be caused, no matter what. Now, if you go to section 299 clause 2, that with the intention of causing such bodily injury as is likely to cause death. Now the sentence appears to be very simple, as if it is not having any such kind of particular interpretation in it. But I must tell you that it is carrying two specific subjective and objective tests. The first subjective test of this section is that with the intention of causing such bodily injury. So here, the mind of the accused will be seen, that which particular specific bodily injury he is causing. Now, we're going to see this by seeing the conduct of the accused, that exactly what he's about to do, the kind of knowledge that he's having in his mind, so that that particular bodily injury he's about to cause against a particular victim. Now, the second test which is having is likely to cause death. Now, it will be an objective test, because this word likely, it is not to be decided by the accused. The word likely, it's need to be taken due consideration from the very fact that may possible that a medical opinion or a medical report will be taken out from this. So exactly what happens next? The third clause says with the knowledge that he's likely by such act to cause death commits the offense of culpable homicide. Now, what exactly we are seeing in this particular section, that the degree of mens rea, the degree of malice is getting decreased at every level. It is in the descending order. So here, the accused is only having the knowledge. Now exactly what's need to be seen in this particular scenario is that it is a kind of formula or whatever you can say it, you always have to read section 299(1) with section 301. Apart from that, you need to study 299(2) with respect to 300 clause 2 and 300 clause 3. And apart from that, whenever you're going to the 299 clause 3, it is always need to be studied with 300 clause 4. Now, as soon as the essential ingredients of each part gets proved in the section 299 culpable homicide, then prosecution will be getting directly upon section 300 because it will try his level best in order to get this killing or this liability from 299 to 300. As I rightly said earlier, that section 300 is also having various exceptions as well. It is having 5 exceptions, and the policy behind those exceptions is that accused will not be getting totally discharged because killing has been done. Because in both section 299 culpable homicide not amounting to murder and section 300 murder, the actus reus, the consequence of a particular act, is death, because a death is getting caused. And apart from that, as far as mens rea is concerned, then all these necessary elements need to be proved, which are mentioned under 299. They need to be taken care of in section 300 as well. So what exactly will happen in case if all the essential ingredients of your section 299 gets proved and you prove all the corresponding elements of section 300 as well side by side? So the thing will be happening. Now the defense will be raising the plea under section 105 Indian Evidence Act in order to prove all his explanations with respect to 5 exceptions. In case if there will be attraction of any of the 5 exceptions as provided under section 300, then the killing will be getting back to the liability under section 299 and the accused will be punishable under 304 of IPC. So now moving on to the subject matter of murder. Now it is very rightly said that except in the cases hereinafter expected. So it is totally talking about all the exceptions. We will be talking about that later on. The very next phase, that culpable homicide is murder. Now it is proving itself that murder is nothing but is culpable homicide. As I said it earlier on, that culpable homicide first get proves only that murder can be proved, because it's a basic principle. It is the interpretation of IPC regarding both the provision 299 and 300. You can't prove murder without proving culpable homicide. And what exactly murder is, it is only and only aggravated form of culpable homicide itself. Now, if the act by which death is caused is done with the intention of causing death. Now, if you see section 299, the very first line, that whoever causes death by doing an act with the intention of causing death. And the same thing you're going to find in section 300 clause 1, that culpable homicide is murder if by act by which the death is caused is done with the intention of causing death. So you must be of the opinion that if both the things are same, then what was the need to write the same language, because substantially each and everything is same. So what legal jurisprudence provides about this matter is that whenever you prove section 299 clause 1, automatically your section 300 clause 1 gets proved. And the reason behind can be multifold, or I should say it is twofold only. First, that there should be a genus and species relationship in order to preserve that. And apart from that, exactly what is needed, it is the language of the legislature. It should not be violated in any circumstance, because it is clearly mentioned before that the culpable homicide is murder. So first you need to prove culpable homicide. And the third thing, which is taken to be the due consideration, that in case if there will be any attraction regarding the exceptions provided under section 300, then the liability of the person will be going back to section 299 culpable homicide. Now, if you go by the very second clause of section 300, it is clearly mentioning that if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. So exactly when you're going to the section 300 clause 2, first you need to read it with 299 clause 2, that is, if the act is done with the intention of causing such bodily injury. This bodily injury is a specific bodily injury. For example, if you're hitting the rod iron rod on the head of the victim. So it is as simple as that. The act need to be particular. He was having that intention to cause that particular bodily injury. He want to hit on the head of the victim, and he does it. So what is different between section 299 clause 2 and 300 clause 2 is as simple as that. The species element, or I should say the additional element in order to get a killing proved under section 300 clause 2 is that there should be a specific knowledge of the accused regarding a peculiar circumstance. For example, the accused was very well aware that the victim was infirm, he was not well, maybe possible he was having a swollen appendix. So exactly hit at that place. So this is the additional element, or I should say the species element, in order to prove this killing under section 300. Now if you go by section 300 clause 3, if it is done with the intention of causing such bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. As I rightly said earlier, that section 299 clause 2, it corresponds with section 300 clause 2 and 300 clause 3. So what is the difference between 300 clause 2 and clause 3? Section 300 clause 2 is directly dealing with the element of a very peculiar knowledge that the accused was having regarding the victim. But in this particular case, in section 300 clause 3, now accused is not having any such kind of particular knowledge, such that the act which he is doing, that act should be sufficient in nature in order to cause the death of the victim. Now, what exactly is happening? First, there will be an objective test, that is of the accused. Then there will be a subjective test first of the accused, then the objective test, and the additional element of 303, the species element, is such that the injury which he has caused to the victim, that should be sufficient in order to do the death of that particular victim. Now, this will be an objective test in which a medical opinion in the form of report or a medical certification which will be needed, but only a medical examiner can provide so, that whether that particular injury was sufficient enough or not in order to make a liability regarding that it is likely to cause death in each and every circumstance. Now, if you go by section 300 clause 4, then if the person committing the act knows that it is so imminently dangerous, I'm focusing on the word imminently dangerous, that it must in all probabilities cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Now, when we talk about section 299 clause 3, all the genus elements which it is imparted, it's already proved whenever you get the killing back to section 300 clause 4. So now, what is different? The different is the species element that section 300 clause 4 is having. And that particular species element is nothing but other than the act which he is causing, it is imminently dangerous. That suddenly it will create some harm. Deaths will be caused. I would like to recall once my mentor was during my college days used to make me understand this provision. That in case if you want to use this provision for the subconscious memory of your mind in order to make it remember, always remember the incidents of Hiroshima and Nagasaki. Just like America has just simply thrown away the nuclear bombs from the sky. So they can't take me that no, we are not having intention. We are not having intention to cause particular bodily injury, because they were having the knowledge that death will be caused in each and every kind of particular circumstance. So this is the theory of entire culpable homicide and murder that they are carrying for the time being in question. Now, if we go by all the exceptions, or I should say the 5 exceptions which are provided under the subject matter of section 300, and they are much necessary for 300, because as soon as any one of the exceptions gets attracted after proving of culpable homicide under section 299 and all the proving of in addition to the species elements of section 300 with regard to all the corresponding provisions. So exactly what will be happening now? In case if there will be attraction of any of these 5 exceptions, the killing will get back to 299. And you will not be punishable for murder. You will be punishable for culpable homicide not amounting to murder under section 304 IPC. So the first exception that it is carrying is that when culpable homicide is not murder, provided it is a case of grave and sudden provocation. So particularly to this grave and sudden provocations, we are having specific elements, specific ingredients. First, the provocation should not be given from the side of accused. Secondly, exactly what is taken care of for this particular scenario is that the provocation should be grave and it should be sudden. And you must kindly note that the word sudden is written with provocation, not the act. It is nowhere written in entire IPC or in entire exception 1 that the act should be immediate about that. The word grave, it itself suggests that it should hit the mind of the accused if it is given by another person. And the provocation needs to be sudden. It should not be pre-planned. It should not be premeditated. It should be on the face of it during the scenario when all these things are taking place. So this is the theory behind grave and sudden provocation. Now, accused can do the death of whom? Either of the person who has provided grave and sudden provocation, or in case he is not doing the death of that person who has provided grave and sudden provocation, he has done death of any person, any other person apart from accused, apart from the victim, from whose end the provocation was received. But if any other person's death is happening, apart from the person who gave that proper grave and sudden provocation, then that death must occur by way of any mistake or fortune. So these are the things which need to be taken care of from each and every scenario regarding this particular point of view. Now, as soon as we move on, then this particular exception is already having 3 provisos. Now the provisos appear to be really simple, that the provocation is not sought or voluntarily provoked by the offender, as it was rightly discussed earlier on by me. The second thing is that the second proviso, that the provocation is not given by anything done in obedience to the law or by a public servant in the lawful exercise of the powers of such public servant. In case it is under the color of his duty, he is rendering all his official functions. So therefore, he can rightly take the plea. As during the course of that particular nature, these things usually arises. Now, if you go by the third proviso, it is stating that the provocation is not given by anything done in the lawful exercise of the right of private defense. If you have done something wrong and somebody is using his right of private defense, then you can't use or any excessive force against him in order to cause his death. Then you will not be getting any such kind of defense. Then you will be liable for murder itself. Now, coming on to the exception 2 of section 300, then it is talking about that culpable homicide is not murder if the offender in the exercise in good faith of the right of private defense of person or property. So if you go by the provisions of section 96 to section 106 of IPC, which is carrying all the provisions related to private defense, so there have been different demarcation. Due to paucity of time, it will not be possible in order to highlight each and everything regarding those connected provisions as well. So there is different kind of demarcations has been provided, that to which extent you can cause death in order to use your right of private defense against a person or against your property or any other's property or any other's body. So in case, if in good faith also, you violates your right, you just simply cross the limit which has been provided by the Honorable Legislature via all the limits which they are embodied under section 96 to 106, then you will not be getting a complete defense here, because in some way or the other, as all the essential ingredients of 299 and 300 are duly proved against you, then there can't be totally a complete blanket order regarding your non-conviction can take place. The best thing which can happen is that you may not be liable under section 300, but you will be liable for section 299. So coming on to the exception 3, then culpable homicide is not murder. Generally, it is covering the cases of public servant or aiding a public servant, in which your section 76 and section 79 comes into play. That is mistake of fact, either justified by law or it is bound by law. So now, exactly what happens in these cases is that if you are totally misusing your position as being a public servant, there is exactly nothing to care about. You're harassing the people, then you will not be getting any defense. You'll be liable for murder itself. Just that by mistakenly, or the situation is so much adverse that you need to take some strict actions in these cases as being a public servant. If all these things are duly proved with respect to all the things that are coming into your regime, then only you will be getting an exception, and then only your guilt will shift to section 299 once again. Now, if we go by exception 4, then culpable homicide is not murder if it is committed without premeditation in a sudden fight. Now, it is so much similar, it appears to be so much similar to exception 1, which is talking about grave and sudden provocation. But how it is different in exception 4 is that exactly there is a quarrel between two or more persons, and it is totally immaterial that who initiated the quarrel. But there are some different factors that need to be taken into the consideration, is that there should not be any cooling off period, and there should not be any premediation, there should not be any pre-planning. All that has happened, it should have happened in the due course of time itself, on the very situation where this quarrel has started. And some of the persons who are involved in that quarrel, he causes death of another. So if all the things of exception 4 comes into play, so exactly what will be happening from now is that you will be getting an exception, provided if all the essential ingredients are proved. Now coming on to the explanation of exception 4. As I rightly said earlier on, that by virtue of explanation, who initiated the quarrel, who started the quarrel, it is totally immaterial in this particular point of view. Now, moving on to the exception 5, that culpable homicide is not murder when the person whose death is caused is being above the age of 18 years, suffers death or takes the risk of death with his own consent. As simple as that, it may be understood by virtue of an simple illustration. Let's say if X is having age of 20 years, 19 years, and he asks B by just keeping an apple on his head, they try to shoot it out, then he is taking the risk himself. So though Y, who is shooting at X, particularly targeting to that apple, he will be liable. But he will not be liable if it was consented by X itself, provided he was having 18 years of age or above that. So only then he will be getting the kind of exception in that particular scenario. So these are the cases which is taken to be care of. Now, if we go by the regime of transfer of malice, so what is the principle of transfer of malice that are coming into due consideration is that only that malice can be transferred which the accused initially have. Now, it may be understood by way of illustration. Sure. It may be taken into consideration that if X was having a good intention to cause a grievous hurt to Y, and by mistakenly he done that particular act in that particular direction in order to do a grievous hurt to Y, but suddenly there is a certain kind of force, a push or pull, Y just get alongside from that. He just simply crosses, and exactly what happens? Z comes into picture. Z receives a very heavy blow. Let's say he receives a bodily injury, and that bodily injury causes his death. So here the malice that will be transferred in this case, it will be of grievous hurt and not of death. So exactly what will be happening in this scenario, that only that much malice can be transferred which the accused initially had in his act. Now we are having some different propounding doctrines, or I should say legal maxims, known as causa sine qua non and causa causans. As simple as that, causa sine qua non, it is the initiating factor, which initiates the act. It is not the dominant factor, which exactly, if we take example of murder, then it is not that particular thing out in this particular scenario that yeah, death must be caused or anything of like that. If somebody has just used a knife against a person and he just gave him a blow or he stabbed in his leg, and after that he calls ambulance and the ambulance driver takes him to the hospital, and in the hospital it is the ward boy who has operated him out. So exactly what is happening here, the axe who has just stabbed into his leg, he will not be coming into the consideration that exactly he will be liable, no doubt about it, but he will be liable for causing grievous hurt. But as the operation was done by a ward boy of the hospital, so therefore, the causa causans, which we also know as the dominant factor, or you should say a decisive factor, as per which the guilt of the accused is concerned. So now this ward boy will be separately liable, and he will be liable either for culpable homicide or either he will be liable for murder as per the facts and circumstances of each and every distinct case. So now if we go by all this due consideration, as there was one more thing regarding exception 1, which talks about grave and sudden provocations. Now exactly what has happened in due course of time, the Honorable Judiciary has propounded various doctrines into that. And one of the doctrine is of slow sudden provocations, slow provocations you must say. It was propounded by the case of R versus Ahluwalia. Generally, we are having different class of persons around us. They must be having some different kind of capacity in order to take the things out. They may not get so much agitated. They may not get so much tempered, losing of their tempers. So they are very good at it in order to make their mind. But exactly what happens, all the anger which they used to gather, it keeps on piling up. And suddenly one day when each and everything gets burst out in their temper, then they may not be, or I should say, they will not be getting defense under exception 1 of murder. That is, on grave and sudden provocation. Though the provocation was grave, but it was not sudden. For example, if we take cases of women's, then they must be having a different kind of taking the things from their end. They can survive. Exactly what we have seen. The same example can be illustrated in the categories of bonded laborers. The same thing can be done in the cases of slavery as well. So they are not in that positional bargaining in order to do each and every kind of thing against their owner or against their family members in case of women's. But yeah, the provocation gets keep on increasing. May possible at a very slow rate, but yeah, one day it usually comes when these persons who are at the bottom end regarding the positional bargaining, so they do that kind of act. And when generally these cases come into the court of law, so what exactly happens at that particular point of time? The defense always raises the plea of 105 and they don't get the right because the provocation needs to be sudden. But yeah, in R versus Ahluwalia, as it was rightly propounded by the English courts, that yeah, there is a policy or there is a doctrine of slow sudden provocations. But the thing which is taken into due consideration is that this theory of slow provocation, it is not at all considered to be a matter of right. It is totally discretion upon the courts, which they will take into due consideration that whether to provide the accused the defense of this slow level provocations or not. So these are the things which comes into picture. Now exactly what happens, as we all know, that either it's a case of culpable homicide not amounting to murder under section 299, or it's a case of clear-cut murder under section 300. The cognizance will always be taken by magistrate under section 190, because these are the exclusive offences which are dealt by court of session itself. And if you want to look at the power of court of session, that you may kindly take note that under section 28 of CRPC, the powers of court of session and the power may be read as that they may pass any sentence as authorized by law. And on the very other hand, if they are passing a punishment of death, then it is subject to confirmation by the Honorable High Court under section 366 CRPC. So this is the entire subject matter of murder. Though there are some different additional things as well, which will need to be taken care of in due course of time. As we all know that there should be a genus and species relationship between culpable homicide and murder. And whenever culpable homicide is proved, you must always take into your consideration that examination will always be going into the domain of murder. And who will be taking this examination? It will be the efforts of prosecution itself. After that, the time you prove your culpable homicide, section 299, and your murder don't get proofs, then the liability will be of culpable homicide itself. In case if you prove your culpable homicide and the essential ingredients, or I should say the corresponding species elements of murder also gets proved, then still it will be happening. Your liability will lie under culpable homicide itself in case if there will be any attraction of the exceptions which have provided under section 300, which we have just discussed. And apart from that, if there will be proving of all the essential ingredients of culpable homicide, you prove all the necessary additional elements of murder, and there will not be any attraction of any of the exceptions as rightly provided under section 300. All the 5 exceptions, there will not be any attraction, then there will be a clear-cut case of murder. So what exactly happens in these cases? As we have discussed, section 299 has been proved. We rightly discussed that 299 1, 299 2, 299 3, and how they are need to be studied. They are of the utmost importance. The time you make a command over this domain, over this particular formula, which has been propounded by the judiciary itself via its wide decisions. They try to read section 299 first line, first clause with 300 clause 1. Try to read section 299 clause 2, either with 300 clause 2 or 300 clause 3, as per the given facts and circumstances in which you need to apply your own juridical prudence in order to form your opinion that whether you will be liable under this or that. Always try to read section 299 clause 3 with section 300 clause 4. Only then the entire subject matter of both your murder and culpable homicide subject matter will getting proved. Because the command which will be making in this particular scenario, it is of utmost importance in order to make your concept well versed with the entire things. Now, earlier it was left by me that section 299, it's also having 3 explanations under it as well. The first explanation can be read as wherein the cases there is a kind of disease, disorder, bodily infirmity in which the bodily injury caused by the accused, what it actually does, it accelerates the death of the victim. So here it is the deemed case of causing death. He can't take the plea that he was about to die, I was not at the very wrong hand, my bodily injury was not of that level, that is, death will be caused in each and every particular circumstance. So in cases there will be an acceleration of death by the bodily injury caused by the accused, then it will be deemed that he has caused his death. Now, whenever we talk about Section 299, Explanation 2, then it talks about death by bodily injury. In case if there is no remedy is available at that time. For example, if somebody has stabbed a person in a jungle and he left him, provided in due course of time, if he would have been taken to a very skillful doctor or been taken to the hospital, his life could have been saved. So accused can't take this plea that no, I was not wrong at my end. If he has done this particular act, so exactly what is going to happen if he don't max out with the remedies and all the skillful treatment, the accused will still be liable for his bodily injury of causing death of this person. Now, the thing which we are having regarding and pertaining to explanation 3 of section 299, it is talking about the death of the child in mother's womb. So due to paucity of time, it will not be very much feasible for me, because for that there should be a clear demarcation between the provisions of miscarriage and the provision which we are having under 299. But yeah, I will slightly touch upon this particular topic, that exactly what happens. You may kindly divide the time period of pregnancy from the first day to 9 months and 10 days. For the first 3 months, this is called as the initial period, in which you may term it as stage before quick with child. Now the second stage is the advanced period, which go on to the 9 months before delivery. But yeah, in case after 9 months and 10 days, even if the slightest part of the child comes out and death is caused, then there will be conviction under section 299 itself. Their accused can't take the plea that the child has not breathed, the child's body parts were not in that position. But provided if 9 months, 10-day period comes into a conclusion, it gets over, then from that particular point of time, if death will be caused, then the conviction will be under section 304, because it will be an act of culpable homicide, not amounting to murder, as per the explanation 3 of section 299. So these are the cases which need to be taken care of. Now, one thing should be discussed upon this particular subject matter, that is, there should be a proper demarcation between section 299 and 314, which talks about miscarriage in particular circumstances. In 299, the intention is to cause the death of the woman. But whenever there is a case of miscarriage, especially under 314, the intention is to cause miscarriage and the act causes death of the woman. So these are the things which taken care of regarding all these subject matters. So now coming on to the subject matter of attempt to murder. Now, as all the subject matter covering the provisions of culpable homicide under section 299 and section 300, murder, stands duly proved regarding all the subject matter from my end. In case if anybody is having questions, then later on they may discuss upon so. Now, attempt to murder has been provided under section 307 of Indian Penal Code. An attempt to culpable homicide lies under section 308. So exactly what happens, it is very simple to understand the subject matter of attempt to murder, and that is, if all your essential ingredients of culpable homicides, that is the genus elements, and all the additional elements, the species elements of section 300 are duly proved. But one thing is missing, and that is actus reus, that is death of the particular person which you have caused. Then it will be a case of attempt to murder and not murder. The punishment has been provided under the concerned section itself. It is mentioned under 307. But yeah, there are different kind of cases as well. For example, if X is aiming towards Y in order to shoot him from 0 point range, and somebody pulls him off, and let's say instead of Y, Z comes into between, and Z dies on the spot, and the intention was to cause death of X, of Y. So exactly what is happening here is as simple as that. As far as the liability against Y is concerned, then X is liable for attempt to murder. But as death of Z has been caused in place of Y, though by mistakenly or by misfortune, then probably, and he shall be liable for murder itself. Because, as I rightly discussed earlier on, the transfer of malice will also come into picture this time. So here, X will be having dual liability in terms of Y, which he got crossed, which he got misplaced, which he just simply saved his life by moving from the particular spot from which he was targeted at from 0 point range from his gun. So there he is completely liable for attempt to murder, as life of Y has been saved. But on the very other hand, if we talk about Z, who got shot by it, he is liable for murder, clear-cut murder for that. So on the contrary to that, if you go by section 307, then all the essential ingredients of murder is proved. That is, ingredients are section 299 plus section 300, plus there is no attraction of particular exceptions as provided under section 300 murder. But there is absentia of actus reus, or the case which I have discussed. So here the liability which the accused will be having, it will be imprisonment which may extend to 10 years plus fine. And in case if there will be any kind of hurt in the sense of a physical injury or injury as the case may be, is caused to any person by such act during that attempt, then he will be liable either for life imprisonment, or the imprisonment may extend to 10 years plus fine. Now the third thing, in case if such an attempt is done by one of the life convicts, already a person is under going through life imprisonment, and he do this kind of attempt to murder, then he may be punished with death as well, provided either he may be provided punishment with life imprisonment, or which may extend to 10 years plus fine as well. But yeah, here the judicial officer is having the appropriate authority in order to make him liable for the punishment of death as well. Now, whenever we talk about section 308, that is attempt to culpable homicide. So here, what exactly has happened, as if you go by the basic principles of 299 and 300, then your liability was only having under the domain of section 299. Either there will be not be any proving of your species elements of section 300, or in case of both the essential ingredients under 299 or 300 is duly proved, but there is an attraction of any of the exceptions as provided under section 300, and there is absentia of actus reus either in toto, or else somebody else has come into the picture. So therefore, this particular thing will be taken into the due consideration, and the punishment which accused will be having in these cases, that may amount up to 3 years, either with fine or either with both. So exactly, in case if hurt or physical injury or any injury takes place in this scenario, then this punishment will be extending to the maximum limit of 7 years, either with fine or with both. Now, there is one more particular thing. All these cases, whether you talk about culpable homicide not amounting to murder under section 299, or else you want to talk about section 300 murder, or you want to go into the domain of section 307, which talk about the offenses related to attempt to murder or attempt to culpable homicide in 308. The cognizance will be taken by the magistrate itself. And all these offenses are triable by court of session. So the commitment to court of session after taking the due cognizance will be done by magistrate by virtue of section 209 of CRPC itself. So these are the things which clear cut serves as the basic nature regarding the entire criminal legal prudential. Now, at last, I would like to discuss upon the kind of evidences, the role of evidence in the cases of these heinous crimes, that is murder, culpable homicide not amounting to murder, or in every other criminal offense which is considered to be of heinous nature. Either you may talk about section 376, rape. The problem that all the judicial officers face in this particular scenario of cases is that we don't have any direct evidences. There is hardly any case, or in case if there are cases, then they are so much restricted to those particular scenario, very few in number, to be honest. So each and everything under the domain of present evidences, they are so much reluctant towards the circumstantial evidences. Bhavna, you want to say something?
Yes, I want to say
Please
something.
proceed.
Maybe some people, for some people, your voice is not clear. Please check. They have written in, in the chat box and a Q&A section.
I'm not able to see that.
Okay, so so there's this Q&A section.
Yeah, we're proceeding towards that after the dealing of this last issue. And this issue is pertaining to the kind of evidences. Yeah, it's audible, fine. Fair enough.
Okay then.
We received a message from Shivang Verma. So yeah, the thing is that the evidences that usually we get in these murder cases and attempt to murder cases are of totally circumstantial in nature. So exactly what is need to be done here? We need to formulate series of facts. We need to frame a particular chain. For example, we may pay focus towards Section 6 of Indian Evidence Act, resisting by forming parts of the same transaction. Either we will be going to Section 7, which is covering various subclauses, just for example, the after effects or any other thing, the causation of death. In Section 8 of Indian Evidence Act, we must be having something related to preparation, the conduct, and the motive, which plays a very keen role in order to formulate a very judicial and a reasoned decision. Because here nothing lies in black and white. Each and everything comes under the domain of gray. Because each and everything needs to be taken care of. As it was rightly said, time to time by the judiciary, that it is better to acquit 1,000 persons instead of convicting one innocent. So the problem in these cases is that there is very big lacuna related to direct evidences. So here usually the problem lies. Now, I think by considering the paucity of time, we should start with that question and answers. Will that be fine?
It sounds nice. Yeah. So we are done with all the topics, no?
Yeah, the topics which have been assigned, they have been clear-cutly done.
Okay, so attendees, if you have any question, kindly write into into the chat or in Q&A section. Yeah. Also, there are some already some questions in Q&A section. What is the difference between provision, volunteer provocation, and private defense? Can you see the Q&A section?
I'm able to see that.
Okay.
Do we have Abdul Nasser here? Abdul, are you here?
Kindly write in the chat. Hello, Mr. Abdul. I think he's here.
Okay, anyway, I think I should deal with the question.
Yeah, he's here. I mean, I can see him, but yes, he said yes, sir, in the chat box.
Yeah. So yeah, as he was asking, what is the difference between provisos, volunteer provocation, and private defense? Abdul, I'm not able to understand your question, but yeah, by applying my own prudence, I think you must be asking about proviso related to provocation. If it is related to provocation, then each and everything has been discussed in clear cut. I will repeat it once again for you so that you may have a very brief understanding, that too comprehensive in nature, in order to make you understand for this particular provocation part. So, Abdul, what exactly happens in grave and sudden provocation cases is that grave should be read in terms of something which will affect your mind, and that too spontaneously. There should not be any such kind of premeditation, there should not be any kind of pre-planning. All such things comes into picture on the very outset. And the word sudden, always try to read this word sudden with the provocation, because it is used for the provocation itself and not for the act. So here what exactly happens, offender is deprived of the power of his self-control. And now, by due to grave and sudden provocation, he causes death, either of the person who gave him that grave and sudden provocation, or other person by mistake and accident. So what exactly is happening here, that there should be absentia of planning of or and of cooling period. And if you kindly note that cooling off period, what exactly it does if it comes into picture, that it leads to controlling down of aggravated stages. Now, the fault of accused is also involved, as he has lost his temper on grave and sudden provocation, therefore he will not be getting acquitted. If he will not be convicted for murder, then he will be convicted for section 299 itself. Now the another question which you were asking regarding that private defense, then in the cases of private defense, what exactly we are having, that in good faith, section 52 of your Indian Penal Code is of due importance here. Now you are exceeding the right of private defense, either of person or of property, either of yours or of any other person. You're exceeding the right which has been rightly provided by the legislature, but that too in good faith. Good faith is one of the most essential ingredient of exception 2. Now exactly what happens, you causes death of a person, but there should be happening that particular death without any premeditation and without any intention of doing more harm than is necessary. So these are the things which are taken into due consideration with respect to your private defense part. Now in case, I think there is one more question, what is the difference between oral evidences and documentary evidence? It is as simple, all the statements that are coming into picture, for example, if there is a statement of a bystander, then forming part of it just under section 6. If the transaction is not getting breaked at any point of time. If police officer is recording statement regarding his investigation under section 160, then they are also proving part of oral evidences, though they are only used for a limited purpose and they are not admissible in the court of law. And now if we talk about documentary evidences are the physical evidences. For example, if you're having a registration deed, a sale deed, you're having a suicide note, so it is accompanied in the form of document itself. So these are formulating the regime of documentary evidences. So this is the basic difference which lies among both the terms. Are we having any other thing, Bhavna?
Yeah, I do not think there are some more questions, but if you have any questions, attendees, kindly write in the chat, or you can write to us. We'll provide your email, provide our email addresses. You can write your questions to us, and yeah, we'll revert back to you. Yeah, yeah, I can see no. I can't see more questions. So I have two questions. Is it fine if I ask? Yeah, because already it is already 3.
Yeah, it's up to you. So I think it's a time for wrap up.
Yeah, yeah.
Yeah, that's fair enough.
Okay,
So really, I'm highly honored for Law Seeku. Bhavna, thanks a lot for cooperating with us. And I think that some of my mentors are also available. I would like to thank Ashish Raneja, Rohit Rohila, Digvijay Singh, Vikrant Sarwan, and especially I would like to thank Mr. Ramanuj and Mr. Abhyuday for providing me this opportunity. And truly, I'm honored. You guys are doing a very nice job in order to provide all the literacy to the law students, which generally we don't get during our law schools, because I have seen a lot of things which you have discussed in your upcoming webinars. So you guys are already doing good. So I may take your leave right now and thank each and every attendee who was present in this particular section. So thanks a lot, Bhavna. I think now it's time to say
thank
bye bye.
you. Yeah, thank you, Mr. Mohit, for joining us. Thank you, everybody. Bye, everyone.